Every day in the USA, people find themselves in court.
We will go on the record in the matter 24 CF 156, State of Wisconsin versus Nicholas Morseth. The state appears through District Attorney Kevin Schmidt in person. Mr. Morseth appears in person with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Davis, please recite it for the record.
Your Honor, in case number 24, CF 156, Mr. Morseth is going to plead guilty to count 4, which is a misdemeanor battery. It's my understanding that the other counts would be dismissed. And the reason for that is I believe my client has already paid the entire amount of the restitution. It's my belief that the state is going to be arguing for a withheld sentence and probation with conditions. And it's my belief that as part of our agreement, the state was going to allow the defense to be free to argue. And whatever the court costs and fine are, the defense will be stipulating to that. But I believe that to be the agreement, Your Honor.
All right, dismissing outright or dismiss and read in?
Dismiss for read in is what I always assume.
Okay.
I guess we didn't really knock that down. I guess I assumed because he had paid the restitution, there wouldn't need to be a read-in charge, but I guess it doesn't matter because I think the court can take into consideration even outright dismiss cases. So it doesn't, I don't think there's any benefit whether it's dismiss and read in. So I'll let the court decide what they want to do.
Well, Mr. Morseth, why don't you decide what you want to have done with those other charges? Dismissed and read in means that the court can look at both dismissed and read in, but with dismissed and read in, it means that once they are dismissed and read in, you can never have other charges related to those again or this incident. Dismissed outright means if some other evidence comes down the road in a week or 2 or 3, the district attorney could charge you again with those.
We'll stipulate, I'll advise my client that dismiss and read in is acceptable, Your Honor.
Yes, Mr. Morseth?
Yes, Your Honor.
Okay. All right. So that is the agreement that's been reached. I believe we have a witness here or a victim here who would like to make a statement. Ms. Bauer, the victim can come up here. He can state his full name or initials if he wishes.
Richard E. Yeager.
All right. Can you please speak into the microphone?
Sure.
And just let me know what you wish for me to know. If you are reading something, please read it slowly and enunciate your words. Okay?
Okay. Is that better?
That's better.
This attack was about a lock on a pole barn. The pole barn is a very large building that we have at my mother-in-law's farm. She gave me approval to put my enclosed trailer in there that had a lot of our housing items in it. And she also gave me the okay to put a lock of my own on there with my key because nobody else needed to go in there, as how she said it. We were living in our motorhome. We had been living in a motorhome for 3 years around the country. We decided not to stay in Tennessee and to come home and help take care of my mother-in-law and my wife's sister because they were aging and healthy, not too healthy anymore. So we decided to come home. So we were living in our motorhome that we'd been living in for 3 years. We were living in it on the farm, waiting to find a house to buy around the area. I noticed the first time I understood that Nick was at the farm was he came by the motorhome and took a lock off of one of the buildings. And I saw him take the lock back to the pole barn. And I thought that was kind of strange. So I got up and got out of the motorhome and started walking back there, and he had left and went around the building to go to elsewhere. And I looked and I noticed that's not my lock anymore. And I saw him go up to another building further away on the property and park. And I walked up there and I said, Nick, what happened to my lock? And he went ballistic. He started hollering and screaming about, I cut that lock off and I cut it off and threw it in the woods, and put that lock on there so I can get in there because I can't get in there if that lock, and on and on. And so I said, So you took one of the other locks and put it on there. That's what I did. I said, well, I'm going to go get the keys and just check out the shed. And the keys happened to be for her locks, happened to be in the house. So it's about 150 feet, maybe more, from where we were all the way to the house. And nobody was home. There was nobody at the farm. All that 150 feet, all I got was pushing, shoving, screaming, and hollering, and things like, Nick, calm down. If you hit me, you're probably going to go to jail. I'm not afraid of jail. I'm not afraid of the cops. And it was loud and spit flying and really tough. I went in the house, got him. He came in and screamed and hollered the whole time through that. I went out and we were walking towards the woodshed. And we went towards the woodshed and he went in there and he started screaming at me for the whole woodshed being cleaned up because my mother-in-law wanted it cleaned up. So we cleaned it up and we put his hunting gear out in the wood side of the woodshed. And that made him all mad. And he was screaming and hollering about that too. So I said, the heck with it. And I walked away from the woodshed and I was going to go to the pole barn. And I just rounded the corner of the woodshed and bam, I took it right in the back of the head. And I don't think I went down, but I know we were tangling for a while. And I remember looking up and he put a metal item in his pocket. And I had seen his brass knuckles before because he was pretty proud of them. And to me, it looked like brass knuckles again. And the hit that I sustained, I knew I got hit by metal. And it was tough. It was really hard. So there was a tussle where I was trying to figure out what's going on. And blood is just going all over from me. And we were fighting and I was losing. And a little bit of a difference between a 63-year-old guy and a 42 or 43-year-old guy at the time. He finally stopped fighting and it was weird because we were fighting and I had lost my glasses and all of a sudden he hollered out, stop. And I remember hearing that, stop. And he stopped and got off of me and walked away. I was like, well, that was really weird. So he went up towards his truck, towards that building that we had walked away from. And I had to go into the motorhome to go after my phone so I could call 911 because I was just gushing blood everywhere. And 911, the first thing they ask you is, what's the address? Well, I've known my wife for almost 40 years at that time. I knew the address. I've been to the farm 100 times. We stayed up there for a year at one time. I couldn't remember the address to the farm. So I had to walk out to the street and read the fire number to 911. That was kind of weird. That was it. I knew something was wrong. So 911 showed up. Or no, before that, I'm standing out there just waiting for the police to show up and the ambulance. And Nick comes flying by in his truck and he just goes right on by me and left. And sheriff came and the sheriff took all sorts of pictures and my statement. Ambulance came and they dressed up my wounds. And then we were able to call my wife because she was in town. Don't remember why, that she was running errands with her mom and actually Nick's mother. And she came back and ended up taking me to the hospital, Burnett Hospital. I ended up with 2 1-inch wounds to the back of my head, black eye, scratched through the neck. They took a CT scan because they were looking for brain injury from the impact, and everything was okay for that. They ended up cleaned up the wounds, and we went back home. So that was the story of what happened, to the best of my knowledge. I was kind of floozy there, so I'm not sure how long this whole fight lasted or anything. But we ended up buying a house in Grantsburg instead of Webster because I'm not comfortable being around Webster anymore with Nick living right in this area. So we've done certain things at our house. We have driveway alarms that alert us when a car or a person or a deer comes in the yard through the driveway. We have cameras and security lights all throughout the yard and around the house. We've got double locks on all of our doors. We made guns more readily available inside the house because we're nervous. We don't go to sleep without checking the locks all through the house. We just don't. With the track record Nick has left with us for over the last 20 years, I fear of getting shot from afar. I fear that he's going to be, I live out in the country, and I fear he's going to be out in the woods just like he always does. He's always out in the woods. And I fear for a gunshot one of these days. And I'm really nervous about that. It's scary. And I think he's a smart enough guy that he knows to do this when I'm alone, because he did that perfectly at the farm. He knew I was alone through his mother, that Ethel was in helping, and Ethel's sister, or Nick's sister, went somewhere else. He knew all this, so he knew I was home alone. So I'm paranoid of being alone. I'm very paranoid of being at the house alone without my wife. Nice part about it is Ethel's mom just fell and broke 3 vertebrae in her back, and she's now living with us. So I've always kind of got somebody at home now, and it's a little bit more settling. Very careful about going out to the farm, because you never know. Nick hunts there all the time. It's a little scary to go there, and I check out for cars. I check out the woods. I kind of look around and usually stop at Ethel's uncle's house, the next house down from the farm, and check in with him and say, hey, everything look okay out there? You know, and he knows what I'm talking about. You can't trust anyone that attacks you from behind. That's really part of this. That's kind of the end of the stories and how I feel about it. Now, if it's okay, I'd like to give my ideas of what should be done. I don't think it will be done, but it should be done.
I will allow you to give me your perspective. I just have a couple questions. What is your relation to Nick?
He's my wife's nephew. He's no relation at all to me. And right now, he's no relation to my wife, as she would put it.
Okay.
Those days are over.
Wife's nephew. And
so, and my wife cares for his mother.
Okay. Are they sisters?
Daughter. It's my wife's oldest sister. And we're
okay.
caring for my mother-in-law, my wife's mother.
All right. And then did your fear with Mr. Morseth start because of this incident?
I could say the truth is I knew he was dangerous well before any of this. There's way too much back history that I am not allowed to talk about.
Has he ever been violent or like this with you before?
Yes, with me before, with my wife, with my mother-in-law, with his sister.
Physical like this?
Nobody, not physical. There was something said to me by a family member that Nick's 95%.
Judge, I'm gonna object to this hearsay or this type of, I mean, a lot of this is speculation of what my client thinks and this and what other people are saying. If they were so scared, I'm sure they'd be here testifying too, but they're not.
And yes, I don't need too much, not that it's going to go into or weigh any decision. You have the right to be able to tell me what you think from your perspective as a victim that you would like to see for sentencing. You do know that the state is arguing for what they are arguing for, correct?
Yeah, a misdemeanor is what I understand.
Correct. All right.
I take it, I don't know if I'm allowed to say that we lost 3 felonies out of this. Negotiations.
Per the agreement that's been reached, yes.
Can I talk again?
Yes.
You know, a 43, 44-year-old guy doing this to a 63-year-old guy. I mean, even if I was 43, just attacking someone from behind is just unacceptable. And if we let him go through with this, it's going to happen. You're going to have somebody else in this court with him. That's what this guy is. I was looking to see for some time served, 120 days of time served. I definitely would like to see probation imposed in state sentence. Like I said, the felony charge of attacking an elder is off the table. But boy, I sure thought that would be a good thing that would happen to him. And I guess that's pretty much it. I'd like to see something besides a ticket going to Nick for this. I think a ticket is nothing.
All right. Just so you know, it would never just be a ticket because they're asking for a criminal conviction with probation and withheld, at least that's what the state's arguing. And even if the defense, it does argue for just a fine, there is a criminal conviction that will take place.
Can I offer some photos?
those would have, I believe they would have to come through the state.
I believe they're photos of his injuries.
Of my injuries.
Show them to Mr. Davis.
I believe these look like the ones from Discovery.
The first three came from the sheriff.
Are some of these not from Discovery? Did you take any of these yourself?
My wife did in the ambulance.
And I haven't seen any of these, Judge, if they're not from Discovery.
So that would probably be the start of the non-Discovery ones.
I guess I would object to anything that I'm just looking at last second here.
What about the ones that were in the Discovery? It sounds like there's 3 or 4.
I don't even know if those were the ones that were in Discovery or not. I have no idea to know that. And again, his statement was that his wife took those photographs.
The
Mr.
ones
Schmidt
in-
is looking at the ones that he believes were in the
I just had
Discovery.
those printed off this morning at the sheriff's office.
I could double check real fast because they're all on a shared drive.
Your Honor, can I ask a question?
You're not supposed to ask questions.
Oh, okay. Okay.
But if it's something that you can talk to the victim witness coordinator and she can make a determination of what she thinks.
Okay.
It might take me longer than I thought. I forgot they took a lot of photographs of Mr. Morissette too.
All right, then if there's an objection to the court viewing the photographs,
Those are all Morissette.
then the court will not look at the photographs. All right, is there anything further? Okay, then you can step back.
Nope.
Thank you.
I did find them. They are from the Discovery, these first 3.
The ones from the Discovery, Mr. Davis.
Guess if we're gonna do that, then I didn't know we were gonna be submitting those, and I guess I would wanna submit the photographs of my client, where he was all banged up and bloody up too. I guess I would wanna have an opportunity to show the court those as well.
Then the court will not receive any photographs. All right. Basis for the agreement reached, Mr. Schmidt.
Thank you, Judge. There are 3 main reasons why. 1, Mr. Morissette has 1 prior convictions from 2008.
What was
2,
it for?
it was for battery, and it was similar conduct to this with a family member. 2, he fully paid the restitution in this matter. I should note that the victim was made whole through the Victim Crime Compensation Fund. So this is money that go to the Victim Crime Compensation Fund, which is a finite amount of money that go towards other victims. So I do want to emphasize how important it is to replenish that fund. 3, this is a battery where both people showed signs of injuries. I think Mr. Davis would agree the visible injuries on the victim here are much more severe than his client's. His client mostly had bruises. There was a profuse amount of blood with this victim because of the 2 lacerations that required Dermabond to seal. To that end, they would be able to raise self-defense in this case. All he'd have to do is testify and say, he hit me first, which is what he told the police. Because of that, I think the court knows there's a shifting burden that occurs.
When you said he told the police, who told the police?
Mr. Morissette.
Okay, all right.
Because of how the shifting burden works with self-defense, where the state would have to affirmatively prove who struck first and also would have to show that the amount of force used was the legally allowable amount, with the burden on the state using Blackstone's ratio, which is what beyond a reasonable doubt and presumption of innocence are based upon. I think this is a reasonable compromise. I should add that this was a case with no witnesses and no physical evidence as to who started the fight.
All right, so you believe that it is in the public interest based upon all of those things that you have listed on the record,
Yes.
all of those reasons. All right. Mr. Morseth, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, yes, Your Honor.
Did your attorney thoroughly go over this document with you?
Yes, Your Honor.
Did he essentially read it to you word for word?
Yes,
Do you understand everything on the document?
yes, Your Honor.
Is that your signature on the document?
Yes, Your Honor.
It states that you're pleading guilty to a battery charge. Is that correct?
Yes, Your Honor.
You're 47 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or other medications, correct?
Yes, Your Honor.
No mental illnesses or disorders.
No, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
You're 47 years old, as I went over before. You have a criminal conviction, but only one conviction from 2008. Is that correct?
Yes, Your Honor.
And that is another battery conviction, correct?
Yes, Your Honor.
Did your attorney thoroughly go over your constitutional rights with you?
Yes, Your Honor.
They're identified on the first page of this document. Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that once you give up your rights, you can't come back and say, you know what, Judge, I want to have this. I want to have a jury trial.
Yes, Your Honor.
Do I need to go over your rights with you again, or do you fully understand them?
Yes, Your Honor.
You understand them?
Yes. Yes, Your Honor.
You understand them?
Yes.
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that the state would have to prove that on or around July 7th, 2024, in Burnett County, Wisconsin, you caused bodily harm to victim one by an act done with intent to cause bodily harm to that person without that person's consent? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that upon conviction, you do face a fine of up to $10,000 and incarceration of up to 9 months or both?
Yes, Your Honor.
Do you understand that there's an agreement that's been reached where the state is going to argue for probation and a withheld sentence, and your attorney is going to argue, or is free to argue, for anything the defense feels fit? Do you understand that I'm not bound to follow either of the side's arguments?
Yes, Your Honor.
I could sentence you all the way up to the maximum penalty today if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, the section called the probable cause section, where it basically says what happened and why you were charged with crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact did cause a battery to victim one,
Yes, Your Honor.
and you did not have consent to do so?
Yes, Your Honor.
Are you pleading guilty because you are guilty of this crime?
Yes, Your Honor.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty, Mr. Morseth?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
I believe he did, Honor.
Did he look at the discovery and the evidence and talk to you about that?
Yes.
Did he discuss any possible defenses you have or a lack of defenses with you?
Yes.
And are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
Mm. Oh, Your Honor.
Then as to count 4 battery, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of battery. The other counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think the court needs to place the defendant on supervision. I think what the court's heard today from the victim is extremely impactful. And I want to be clear. I believe that it happened the way the victim described it, full stop. However, I am not the plaintiff for Mr. Yeager in a civil case alleging a tort battery, which would be how you describe a situation where you go in front of a jury or a judge and say, hey, who do you believe? Do you believe Mr. Morissette or do you believe Mr. Yeager? I am the state, I'm representing the public interest, and I'm representing to the court about what we can know to 93% chance 10 guilty people go free is better than one innocent person being convicted, Blackstone's ratio. To that end, what I would say to the court is, because of the nature of his past conviction in 2008, albeit extremely long ago, the court should have paused to place him on probation still now. The reason for that is the 2008 conviction also involved assaulting a family member. It was also involved holding a metal object. In that case, it was a pistol and a flashlight where he struck a family member on the head, causing head injuries. This is similar, very different object. The victim believes it might have been brass knuckles because he's aware that Mr. Morissette owns brass knuckles. He couldn't see very well, knew it was something metal. Mr. Morissette, when he was interviewed, said, I was holding my keys because he was changing the locks at that shed, and it was the keys he hit him with. So it's still a metal object either way. And because of the 2008 conviction, he should know how serious hitting with any metal object can be, whether it be brass knuckles or keys or a flashlight or a pistol. Because of that, and because of also, Mr. Yeager alluded to in the family, there's lots of concern about him that goes beyond the 2008 conviction, whether there's some allusion to it's not physical, but everyone's afraid of him for some reason other than physical. That's another reason for the court to have pause and wonder if there's anger management issues or if there's a greater domestic violence issue that needs to be looked at for Mr. Morissette. I know this isn't domestic violence because obviously Mr. Morissette has not lived with the victim here. But when I use the term domestic violence, I'm not using the statutory definition. I mean, violence against somebody in the family, which I think is probably the layperson understanding of the term. I think that the court's likely going to hear something to the effect, hey, judge, this happened in 2004. He's been on bond. He hasn't done anything since. So there's no need for probation. To that, I'd say just because he's been on bond doesn't mean he's been doing interventions, doesn't mean he's been doing MRT or thinking for change or cognitive thinking things that could benefit his family. And it doesn't give the victim the added benefit of at least some peace of mind that DOC will be monitoring him for this time. Thank you.
Thank you. Mr. Davis.
Thank you, Your Honor. Well, Your Honor, I believe it's a serious offense because it's a criminal conviction, albeit a misdemeanor. He's still not convicted of a misdemeanor battery. But when I look at, I've heard the victim, I've heard his position, I've heard the state's position, but my client has not changed the position one bit. My client did not start the fight, was not the aggressor. He was at his grandmother's farm. He had permission to be there, and no one had permission to put a lock on the shed. And the grandmother instructed my client to remove the lock, and he did so. And that really upset the victim to no end. And the victim was the one who started this, was getting in my client's face, and then the fight ensued. My client never had brass knuckles. He never had any kind of weapon like that or anything. The reason he had keys in his hands because that's what he was carrying. And as he was getting choked and beat, and he was fighting back, it would be the only thing that he had in his hands, metal, would have been a key or keys that he had, which he was out there with. But he wasn't using them as a weapon. He was getting attacked. I believe that my client could have stopped when he got the advantage. And I think at that point when he didn't, I think he even told the officer it was fight or flight. And I think his adrenaline was so much as that he continued fighting when he could have clearly stopped. That's the battery. He had no permission to continue on. It should have been ended and they both should have gone their separate directions. He's now guilty of that. But I would like the court to be aware, the victim is talking about this, but there's been lots of issues at that farm, include Dennis Steverman and Wyatt Steverman would be the nephews of the victim and my client's cousins who had also had altercations with the victim at the farm. Because the victim wants to pretend that it's his farm and he doesn't like any other family members out there and he tries to control things. Now, my client, I'm here to argue and let the court know why the victim was the aggressor and why he was out there. My client has permission from his grandmother to be out there, and anytime he's out there, he gets permission from her. And it seems that the victim doesn't like my client or any other nephew out there. And he doesn't like it and he doesn't want anyone out there. But in any event, this is not the first instance that involved my client in physical altercations. It's also been two of his cousins that have had to be in similar situations. Maybe not to the extent of this, but it's an unfortunate situation. But I don't want the court to think that my client is a dangerous human being and he's out there trying to impose his will on anyone that's at his grandmother's farm, because that's not true. Another thing is a little disingenuous is for 20 years, he's been known that my client's dangerous or he's fearful. 20 years is a long time to contact law enforcement or get restraining orders if those types of activities were occurring. I don't believe they were. I think there were also concerns of alcohol use, not by my client, but by the victim. And it has not been the first time that's been a problem out at the farm or other places near the property. In any event, my client's here taking responsibility. He now has a conviction, battery conviction on his record. What I want the court to know, and yes, we are thankful, my client is thankful, you gave him the opportunity to keep making money, and he worked lots of overtime to pay that restitution up front, Your Honor. And that restitution amount was, I thought, one of the more significant amounts that I've ever had a client come up with, which I believe was $5,909.06.
It was revised to $6,872.84.
So even more than the initial amount that I had then. And he's paid that, and he had to work additional shifts. He works out of town. As you allowed him to do that, he would go and he works in Minnesota or another state, and he was able to pick up additional shifts to make sure that that restitution was paid. Again, and the reason I'm making an argument for cost on this, it's not just because he's paid the restitution. And my client does not want to have any contact with this individual. And my client still has a great relationship with his family, maybe not the victim's wife. And I didn't know that the victim and his wife were even still together. I know there was issue with those two within the past year or two. And I think the state's aware of that. But in any event, my client wants no contact with the victim. He doesn't go or do drive-bys. He doesn't go anywhere near the victim and never will, period. Never, ever happen. He doesn't want anything to do with that part of the family. But I can tell you that Nicholas wasn't drinking. Nicholas wasn't using drugs, and he's never had a problem with drinking or drugs. He's made all his court appearances. I know this has been very serious for him. He's been very stressed out about this. But I think that putting him on probation, yes, the state then, the Department of Corrections can monitor him and make sure nothing like this happens. The last time it happened was 17 years ago, 18 years ago, where he had his one misdemeanor. That's the only record he has. That is extremely long time ago. But I think that probation may not be well suited, because I think those resources could go to people that have addiction issues or need special treatment and things like that. And while I do agree with the state, because I'm not going to lose my reputation in this court or any other court, yes, I agree that the damage was much worse in the victim than it was in my client. That's factual. So I will agree with that. But my client was roughed up very well too, but not to the extent as the victim. But my client does not have any bond violations. He's never tried to mess with the victim, intimidate him, hasn't talked to grandma or any family member about it. He has stayed completely clear of it and followed every court order. And so I think he's earned the right. He's now a convicted criminal with this today. And I think he's earned the right for this to just be a court cost and fine. And again, I'm not trying to be insincere about this, but again, my client did not start the altercation, but I do believe that he could have stopped at the appropriate time. And again, the fight or flight is adrenaline. He continued on, and it should not have happened. And for that, he is wrong, and he should have never done that. And he does apologize for it. Nick is a very shy person. He doesn't do well talking. As you can see, even when he's answering your questions, he's shy. So I'm speaking on his behalf today, Your Honor. Thank you very much.
All right, thank you. I know you said you're speaking on his behalf here today, but Mr. Morseth, you have an opportunity to provide anything to the court, to let me know anything you want me to know. If there's something that wasn't touched on, or if there's something that you feel needs to be corrected or you need to add, this is your opportunity.
Yes. Yes, Your Honor, I'd like to say something.
Then please put the microphone closer to your mouth.
Is that
Thank
better?
you. Yes.
Is it on?
Yes, it is.
Yes, my uncle, Rick, I looked up to this man for a very long time. It was a bad situation, like you said in the previous, hearing with this, there's victims on both sides of the spectrum. I remember that. I remember you saying it clear. And I feel like I was a victim, and I'm sure he feels like he was a victim. Should have never happened, or should have never got to that far on both sides of the spectrum, where he aggressively attacked me, not just once, but 3 times too. Kept coming at me. That's where I come up with I said the fight or flight reaction. I could not get away. And I kept telling him, stop. When we were on the ground, stop. Where's your glasses? Where's my glasses? And after he punched me in the private area, I ended up kneeing him in the face. And that's how the glasses got broken. That's how the black eyes happened. That's when he finally stopped. I said, stop, Rick, we're done. No more fighting. I don't want to do this. And that's when I was able to actually vacate the property. But not until then, he mentioned to me, and I was scared for my life. He said, basically, I'm going to kill you. And I know he has this conceal and carry license. And that's when he had that. He got that prior to before traveling for his safety and his family. I think he has I believe that he has some mental anguish of fear for his life from his travels. And I have no intent to do any harm to him, his family, or anybody. It was just a bad situation that it blew up and got worse. And I've learned from my mistakes, and I'm just as anybody else learns from their mistakes. If they can learn, they're going to better themselves, Your Honor. And this has been a long haul for me this whole time. Working, bonding, making memories with my kids, because I had reconsidered that, and it's been hard. It's been hard for me too, physically, emotionally, because I might worry about seeing my grandma if they're there. So I call, I try to avoid them so there ain't no 2 people at the same time with the restraining order. It's been hard. And I know my grandma's getting up there in her years, and I don't know how much more time she has left. So every moment I can spend with her, it's a gift.
All right, thank you, Mr. Morseth. Well, in sentencing an individual, you haven't been in front of a court for sentencing for a very long time, and things have probably changed since 2008. The court needs to look at the nature and the gravity of the offense. How serious is this case? I have to look at you, your character, your past criminal record, any rehabilitative needs you may have, among other things. I have to look at the need to protect the public. I have to look at the impact on the victim. I have to look at other things as it relates to the public and the public interest. In looking at this case, you are pleading guilty to a battery, to laying your hands upon another person without their consent and injuring them. That is serious. That's a serious crime. You've done this before in 2008, and it sounds pretty similar from the 2008 conviction. So that's on the negative side. On the positive side, you haven't been convicted of anything similar since 2008. It sounds like that there's a lot of family discord. It sounds like, but it's hard for me to gauge and hard for me to tell. The victim, Mr. Jaeger, was very convincing, and this has impacted him significantly. And I understand it has impacted you as well, but you're the ones seated in that chair. you're the one who is now convicted of the battery. What exactly happened that day? I don't know. The only two people that really know are you and Mr. Jagger. Only you two know exactly what happened that day. And it sounds like it was awful, traumatic, not only physically, but emotionally as well. And it didn't only impact you two, it impacted your family and others. And that again makes this a more serious crime. You did plead guilty. You are now, again, a convicted criminal, I guess. You are a criminal. You've been convicted of a crime. You worked hard in order to pay off the restitution, and almost $7,000. That's a lot of money to prepay. And you prepaid most of your court costs and fees ahead of time. So to the court, that looks like you're taking it seriously. There are some things to consider with the state's argument in the fact that there are things that perhaps the court needs to look at. Because again, even though it was from 2008, it is so similarly related of a crime that there's something that goes into that. In protecting the public here, number one, it's protecting Mr. Morseth. Sorry, not Ms. Morseth, Mr. Jagger, protecting him and protecting, his environment. And then the court also has to look at others. Do you have needs that you need to address? Are there resources that you need to reach out to, such as anger management or criminal thinking programming, like Mr. Schmidt has argued? When we're looking at this case, I think it is a positive that you've prepaid the restitution. It is a positive that you are admitting to your guilt. But I do see the state's perspective and argument that there could be other things that you need and you need to address. But that would be up for probation to determine. Probation's the one who will know if you have things you need to do, or if there aren't things that you need to do, how often you need to see probation, if at all. But I think the seriousness of this case does call for probation. So I am going to order 1 year of probation. 1 year of probation, and I am going to do a withheld sentence. Generally, I would do an imposed and stayed sentence, but quite honestly, I want you to understand that there could be a seriousness of 9 months of jail hanging over your head. So if you aren't going to abide by your conditions of probation and do what you need to do, you could go to jail for 9 months. That's a significant amount of time. I believe you were arrested, but I don't know if you've sat any days in jail. Any overnights?
No.
Overnight, I believe.
It was overnight?
Yes.
So,
Oh, no, it was actually longer than that, 'cause I got transported down to Polk County. So I don't know how many days it was. to be honest.
Judge, I'll have to look into that. I don't have the amount of the days.
so, okay, well, let the court know within 7 days what the jail credit is. But Mr. Morseth, you could have 9 months of jail. That's a significant amount of time. I do want to see as conditions of probation, an anger management course with the department's choosing, and a criminal thinking program. Absolutely no contact with Richard Jagger or his wife, but there's a restraining order anyway, an injunction. No abusive contact with any family member. Absolute sobriety. You don't drink or do drugs anyway, but probation won't allow you to do that anyway. I'm ordering restitution in the amount of $6,872.84. $518, oh no, actually $500 in fines and fees. So I guess you have prepaid your court costs as well. You should have all of that covered. Any conditions that I'm missing for probation?
Not for me.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order your DNA. You have to provide your DNA to the sheriff's department. This would be a crime that you could request it be expunged through a written letter to the Department of Justice. You do need to report to probation immediately.
Restitution, the last one we had was.
There's a revised, there was a revised one on August 6th. Was there a revised one to a lower amount? On May 30th,
No, I've got the receipt right here, Judge. You were right, the $6,872.84.
He paid $6,000.
And he's got the receipt for it as well.
There was one in there. Document 16. For $6,872.84.
Well, he's got document 15 on his, but anyways.
Well, yeah, mine is the sealed one.
Oh,
So it's document 15 is the one.
Document 39.
So I'm not sure exactly what the restitution is. He's prepaid $6,872.84. That's one of the restitution supplements that we have. 20 days to appeal. You need to contact probation. Is your address 28482 Fox Ridge Trailway?
Yes, Your Honor.
Telephone ends in 3699. You must report to probation immediately. I believe they close at 4, I think, I'm not certain. But I am going to give you until tomorrow at 4 to report, just in case they are closed. So again, provide your DNA, go to probation and get that set up, and you should be free to go.
We'll talk next week. Make sure you sign up for
And
probation.
we are adjourned.
No. Where's the probation office?
It's kitty corner off the highway.
Oh, over.
Yeah.
Okay. Where was that?
So go see if you can get there today.
Yep.